At least
Don't
one decimal.
Mr. Sarup, don't confuse numbers with volume, or volume with substance.
When it comes to Jnl Singh, para 27.
All right, thank you.
Great.
Yes, Mr.
Three problems with E.V. Chennaiya, as I want to place before your lordships, is the first one is that E.V. Chennaiya goes on the foundation.
Just 1 second, let's make a note of it.
Yes, ma'am. My lords, I'm appearing in I 26773023. This is the Karnataka Madhya 267730 of 2023. This is the Karnataka Madhya Mahasabha members. So the three problems, my lords, with E.V. Chennaiya, the first one is that it tackles scheduled caste as a homogeneous group. A lot of arguments have already preceded me about why it is not homogeneous because of its representation not being homogeneous in natures, there being diversity in occupation and the way they have been dealt with. I would like to deal with that part of homogeneity which goes into the very definition and the structure of what forms scheduled caste. That is my first argument. The second argument is that E.V. Chennaiya in para 39 says that because the subclassification group affects only a minuscule proportion of the scheduled caste community, therefore it is not an exercise that they are willing to undertake at the moment. The argument of minuscule proportion has been well settled by legal tenets, my lords. I would place one of those judgments, my lords, wherein they have specifically held that when there is a right, there is a remedy, and it does not matter whether it is a minuscule proportion or a large. States in Johar, my lords. And the last point, my lords, is that the judgment itself is in violation of the principles of constitutional morality, which has also been expounded in Mphighcourt Judge and the judgments thereafter. Without taking much time, my lords, I would like to rely in my submissions, which is at compilation 1F, my lords. Compilation 1F at page 8, my lords. My lords have page 8, my lords.
1F, right?
1F, my lords.
Numbered page 8.
Yes, my lords. Number page 8, PDF page 12, my lords. I apologize.
PDF page 12, yes.
PDF page 12, my lords. This is an extract from the book Mark Galanter's Equating. In his book, Competing Equalities, Law and Backward Classes in India. And I have placed the book on record, my lords. I'm only extracting the portion that is relevant. At page 8, there was an interesting conversation when the constitution framers were deciding how to define scheduled caste, how to define untouchability. There was a conversation within them whether this is a term that could be defined at all. And I would read point number 2. The very different nature of the matter in the north from the south was brought out in the testimony before the Indian Franchise Commission, Mr. G.S. Pal, representing the United Provinces Hindu Backward Classes League, which had submitted a list of 115 castes estimated to make up over 60% of the population for inclusion as depressed classes in the United Provinces. Dr. Ambedkar asked a very interesting question. My point is this a list of what might be called backward communities, economically backward and educationally backwards? Or is this a list of castes which are called untouchables whose touch causes pollution? Is this the list of castes which are touchable but are educationally and economically backwards? Mr. Pal says this. I respectfully submit that this is a list of all the castes which in the opinion of the League are depressed classes. Untouchability in the sense in which it is understood in Madras or Bombay does not exist here. Bangi is the only caste that is universally untouchable, pollution by whose touch is regarded as something very undesirable. Here untouchability exists, of course, but in a very mild form, or exists in some form or another in all the castes I've enumerated. Then Sir Surinder Singh Majithia asked, how would you then define depressed class of people? To which Mr. Pal responds, not in the sense of the definition by Bombay and Madras, but apparently here, the Hindu class is divided into high and low castes. The problem is very acute as untouchability is in Bombay and Madras. I apply 3 tests. The first is we are socially despised, then there is economic backwardness and educational bankruptcy. J.H. Hutton, which Gopal Shankar Nair, my senior, argued before this, wherein he talked about the different criteria that were put forward. 9 criteria were put forward by J.H. Hutton, wherein he said that are these people who will upper class Hindus will take water from? Will they be allowed access to public convenience? So he placed these 9 criteria before the committee. Then the report said this: the existence of multiple and ambiguous criteria permitted regional variation by giving the census superintendent scope for discretion. Each provincial superintendent was instructed to draw up his own list, taking these tests into account, and to reckon as depressed only those castes who definitely suffer from serious social and political handicap on account of their degraded position in the Hindu social scheme. The final reckoning then did not apply Hutton's test pure and simple. Excluded were some castes which were theoretically untouchable, but who by virtue of prosperity and vigorous organization have built up for themselves a strong position which obviates the need of any special measures for their social, political, or religious protection. Conversely, some groups were included even though theoretically they were untouchables.
They were not untouchables.
They were not untouchables. So therefore, even at that stage, the factors and the criteria that formed scheduled caste as a group, there was no consensus, because India being such a varied country, it was not possible to define what exactly a scheduled caste can be. And that is the reason why, my lords, constitution even today does not have a definition of a scheduled caste. And the point is that the reason that the constitution did not provide for subclassification is because originally, when the constitution thought about bringing in reservation, it was to be only for a period of 10 or 15 years. They did not imagine that this reservation of constitutional protection. Discrete and insular minorities face grave dangers of discrimination for the simple reason that their views, beliefs, or way of life does not accord with the mainstream. Yet, in a democratic constitution founded on the rule of law, their rights are as sacred as those conferred on other citizens to protect their freedoms and liberties. Therefore, the argument that this affects only a minuscule proportion could not have been a foundation of this judgment. My lords, as far as the presidential list goes, my lords, is to creamy layer and apply creamy layer to SCs and STs. Even in that case, it does not affect or it does not have any embargo on the power of the president under Article 341 or 342. This is para 26, my lords.
At page 28,
Page 28, yes, my lords.
Yes.
So therefore, my lords, I'm not reading into this, but Justice Nariman, this constitution bench of this honorable court, has specifically said that by virtue of even including creamy layer, you don't have, it doesn't tinker with the presidential list under Article 341 or 342 of the Constitution. Para 741 of the Indira Sari has been read out, my lords, but the only point is that when they say that Article 61 is a right of equality, and 16.1 naturally includes the reasonable classifications under Article 14, 16.4, which is an exercise of classification, which is what Indira Sani says is 741, has to definitely bring about the exercise of reasonable classification. And the last point, my lords, which is the constitutional morality point, my lords may have the paragraphs from Chennaiya, which my learned seniors already read, para 41 and 113, where they pass the buck onto the state to do something more, rather than doing something themselves, despite understanding that the problem of subclassification exists and the need of the hour is to provide for it. It ignores the provisions, my lords. And page 30, my lords, at the bottom is Nabte Johar, my lords, where the doctrine of constitutional morality has been expounded. And the relevant page, my lords, is at page 31, my lords. This is an extract from Nabte Johar. Para 111, may I read with permission, my lords?
Yes.
Our constitution has often been described as transformative. One of the most important purposes of this transformation is to ensure that by realization of fundamental socio-economic rights, people disadvantaged by their deprived social and economic circumstances become more capable of enjoying a life of dignity, freedom, and equality that lies at the heart of our constitutional democracy. It is the concept of constitutional morality which strives and urges the organs of the state to maintain such a heterogeneous fiber in the society, not just in the limited sense, but also in multifarious ways. It is the responsibility of all the 3 organs of the state to curb any propensity or proclivity of popular sentiment or majoritarianism. any attempt to push and shove a homogeneous, uniform, consistent, and a standardized philosophy throughout the society would violate the principle of constitutional morality. And my argument, my lords, is that E.V. Chennaiya does the exact same. I am extremely grateful, my lords, for the opportunity.
Yes, Mr. Khurshid.
Lords, grateful to Mr. Khanna. He's allowed me to come first. Lords, I would seek your lordship's reward in being for brevity. Lords, just two principles. I think a broad spectrum and the layout is there very clearly before your lordships. Lords, there are two strains that your lordships would examine. One is there's a strain of the difference between vertical reservations and where distributional justice and equity between those two classes are what your lordships can examine, and that would not fall foul of the 341 and the president's power. Well, that's my submission. For this, my lords, your lordships will understand, as always, I have put in an article of Ronald Dworkin on what is equality. Distributional aspects of equality and welfare aspects of equality, including the vision that we come across in the works of Mr. Amartya Sen. Well, that's all I want to say, and I hope I've met your lordship's demand of brevity. I'm grateful, lords.
Yes, Mr. Khanna.
Lordship would give me a minute also, my lord. Kindly have, my lord, my written submissions at page 217, volume 1, my lord.
Which volume?
Volume 1, my lord. PDF page 217, my lord. But partly my senior colleague, Mr. Khurshid, has touched that point. But, my lord, 2 points I want to raise, my lord, they have not been touched. One is, if your lordship will be kind enough to have it 217, my lord, the first 3 points I have raised, my lord, for consideration of this constitution bench, my lord.
Volume 1, page
217 PDF, my lord. The written submission starts, my lord. The first 3 issues I have flagged, my lord. Other issues I am not, my lord, repeating. Whether the subclassification or subdivision of SC/ST declared in the state under Article 341 is permissible under Article 16(4) of the Constitution in order to give them adequate representation in the service under state. In other words, whether the horizontal reservations cutting across the extent provision of the vertical reservation in SC/ST in a state is innately intra-vires the Constitution of India or not. Second, my lord, I am requesting your lordship to consider is whether SC/ST is duly recognized under 340, 341 and 41(2) of the Constitution of India on the basis of the statistical data, and yet their representation in the state services can cogently be given proportionate preferential treatment so as to provide them adequate representation in the such services under the state or not. Third point, my lord, on Article 14 has been, my lord, flagged by my previous colleagues. My lord, I will only request, my lord, to kindly state here, my lord, para 7. I'll just not read para 7 and 8, my lord, where I have, my lord, the golden thread principle and, my lord, Maneka Gandhi, my lord, that Article 14 that serves part of the body, they can't be. Kindly have, my lord, para 19. State way, my lord. Lord, these are the 2 paragraphs which have not been placed before your lordship from Indira Thani, my lord. And I say, my lord, in para 38 of the Chinaya, the lordships have, my lord, missed these 2 paragraphs which were the crux of the judgment. Para 514, my lord, it is necessary to add here a word about the reservation for women. Clause 2 of section Article 16 bars the reservation in the service on the ground of sex. Article 15(3) cannot save the situation since all the reservations in the service under the state can only be made under Article 16. Furthermore, the women come from both backward and forward classes. If the reservations are kept for the women as a class under 16(1), the same inequities phenomena will emerge. The women from the advanced class will secure all the posts, leaving those from the backward classes without any. It will amount to indirectly providing statutory reservation for the advanced classes as such, which is impermissible under any of the provisions of the Article 16. However, there is no doubt that the women are vulnerable section of the society, whatever the strata to which they belong. They are more disadvantageous than the men in their own social class. Para 812, my lord, where your lordships have said we are also of the opinion that this rule of 50% applies only to the reservations in favor of the backward classes made under Article 16(4). A little clarification is in order at this juncture. All reservations are not of the same nature. There are two types of reservations which may, for the sake of convenience, these are the vertical reservation for SC, ST, backward and other classes. And in horizontal reservation, you can provide for different categories. This is what, my lord, your lordship will be now providing for, my lord, in this judgment.
Thank you, Mr. Dhish.
Thank you.
Lordship, volume 1, page number 104. Only 2 minutes, sir.
Yes.
Volume 1, page number 104. Last 2 lines. My humble submission is that for the upliftment, there can be subcategory, under category of SC, ST reservation. But that cannot be done by the state legislature. It can be done by only the union parliament. And for it, only 2 logics. I have.
You on this side or this side?
Sir, let me see the partly this side and partly that side.
No. Hybrid.
Sir, let me say of the 2.
Neither here nor there.
Sir, for
Then
the,
it should have been somewhere between Mr. Meshram and Mr.
yes,
Mishra. You're right over
I am assisting
towards
the
the
court to
advocate
reach
judge.
sir, I am assisting the court to reach the right
So
conclusion.
are you contending that the Punjab Act is unconstitutional?
Yeah,
Because according to it can only be done by Parliament.
yeah, absolutely.
Then let the arguments of the side be over.
But you know what? Why are you preempting their argument? Acha, what do you want to say on it?
Yes, sir, please, sir, it's the request. The interplay of Article 15(4), 16(4), 341 and 342 is not giving power to subcategorization to the state legislature. And second one, the original of the scheduled caste, going back to the Pune Pact, when the it is between the Gandhiji and the Baba Sahib Bhimrao Ambedkar, and it have its origin to the movement for the reservation of the depressed class in the state legislature of that time. And this scheme got the space in the Government of India Act 1935. Scheduled caste is class.
You have opened the batting for the respondents. Yes. But the captain of the respondents has to decide who will open the
Because
batting.
my name is included in the list of this side. Sir, let me say my name is included in the list of this side and it is, so that's why.
All right. Mr.
Yes, sir.
Mishra.
Let me complete 1 point, sir. 1 point. Only, sir, 1 point. Scheduled caste is a class, is a group of classes, origin to untouchability, not to the backwardness, sir. Because, sir, the list of the petitioner side included my name as an intervener in the state of Punjab versus Davinder Singh. Yeah? Client is a private party, sir. Being the citizen of India, it is the item number 701, sir.
So who's the client?
Who is the client? Interpreter or
It is Miss Shela Sharma.
Miss?
Miss Shela Sharma.
Shaila Sharma?
Yeah.
She is belonging to any reserved category?
Yeah, pardon?
Is she belonging to any reserved category?
No, sir, it is the constitutional bench matter and it affects the society in the long run. So that's why.
Right to
Anybody can come and
Yes, yes. That surname with Miss Shaila Sharma
Yeah.
bears with you the commonality. Is there any other link? I mean,
No, sir, it is just the
Differential.
client and it is
All right.
nothing.
that's all. Thank you. Mr. Luthra, then we'll come back to you.
No, sir. So that's fine.
Just take 4 to 5 minutes and
Yes.
Okay, thank you.
1:30, 12:30. And you finish by 1 o'clock. We'll give you half an hour after that.
at least
Don't
one
So, Mr. Sarup, don't confuse numbers with volume, or volume with substance. So you just, that's why we said we give you that time. Chaman Lal ji, आप फाइल कर लीजिए.